Good afternoon, everyone. Thank you all for joining us. I'm Sarah and I'm from the MJA, and I'd like to welcome you to our briefing this afternoon, which is being delivered by Weightmans. Before handing over to our lovely presenter Ingrid, I'd just like to run through a few housekeeping points. I need to advise you that this session is being recorded, so please do ensure that your microphone and camera are switched off. If you'd like to ask a question, can you use the chat button at the bottom of your screen? Your questions will be answered during the Q&A session and will remain anonymous. If, however, we don't have time for Q&A at the end, we can address post-event if you want to provide your contact details. But I've just spoken with Ingrid, and we've agreed that if there are any questions we don't have any time to address, then we will follow up with responses to you all afterwards. So the MGA's Programme of Learning and Insights has been accredited by the Chartered Insurance Institute for the quality of content and supporting materials, with CPD hours applicable if relevant to your ongoing professional development. The recording of this briefing will be available on our website and MGA YouTube channel, with a PowerPoint presentation to follow post-event. Finally, you'll be sent a feedback survey. Please do take time to complete this, which should take no more than a couple of minutes, as this allows us to deliver the best quality events to our members. So, today's briefing, the Employment Rights Bill legal update, what do we know so far, is being delivered by Ingrid McGee, who is a legal advisor with over 19 years cross-sector experience, managing cases from across the employment law spectrum in both the private and public sector. Ingrid is also a member of the Employment Lawyers Association and the Immigration Law Practitioners Association. It's easy for me to say. Before I hand over to Ingrid, we have an opening question to get you thinking, and if you can add any responses in the chat, that would be great. It's quite an open question. What are your biggest challenges as an employer from an HR or people perspective? And that's it for me from now. So Ingrid, it's over to you.
Thank you very much. And good afternoon to you all. It's a pleasure to be here. As we've mentioned, I'm here to discuss the Employment Rights Bill, the legal update and what we know so far. It's been quite a popular topic of conversation for the last 3 or 4 months. So it'll be good to get into all of this with you this afternoon. What I will say is that I have been typically ambitious and have, I think, a number of slides to get through this afternoon, because I do want to cover what I think is relevant to you. I also want to cover off what I think might come into force in 2026 and how that will apply, and also the sexual harassment duty, which I think is something that's really important for you to all be aware of. So I am hopeful that we will get to the Q&A session and there will be time for that. But like we've said, if we don't get to it, we will, of course, follow up for you. So without further ado, just to be clear on the scope of the presentation and the learning objectives for you all today, we're here to summarise the key changes in the Employment Rights Bill relevant to MGAs, again, describing how we see these changes will impact you on a day-to-day basis or from a working practices basis. And again, outline additional changes that are likely to come into force this coming year, again, and the expected timelines around all of that. So the first area I want to cover are the general proposals, and there's been a number of them, but we've kind of handpicked these particular ones to go through today. And just bear with me, I'm just going to change my screen here. So yeah, this is a slight overview of what I think is relevant to you all. And again, it's obviously with the aim to strengthen workplace protections and improve fairness for employees across the board. And that's why, with the particular government that we have in power at the moment, why there's been a particular focus on this. Again, there's areas around crucial issues like job security, family leave, flexible working, and fair employment practices. And again, it is there to strengthen employee rights and workplace protections. But obviously, as a business, as an organisation and an employer, you might have questions around that. You might have opinions as to whether or not it facilitates you in any particular way, or is it a hindrance, or is it a challenge for you. So we'll have a discussion around these proposals as well with that in mind. So the first one I want to go through, which I think has been probably the most, I don't want to say hyped up, but very headline grabbing in terms of the proposals, and that is that the right to claim unfair dismissal will be a day one right for employees. Now, currently, you might be aware that this is a right that you have only once you have completed 2 years service. And the current proposals are suggesting that this will be a day one right. So there is going to be an initial period of employment with a statutory probationary period. That will perhaps allow a lighter touch in terms of the process and a reasonableness test as part of the dismissal process, and there may be less compensation that could be awarded in these particular circumstances. Now, what I will say is that this will put not necessarily a strain, but a genuine focus for businesses to make sure that your probationary period clauses, whether you have them or not, are in your contracts. You're very clear about what is required within the probationary period. And at the moment, what is being proposed is a 9-month probationary period in which you can effect dismissal. Now, that will be challenging if you're not clear on what parts of the probationary period, whether it's performance or conduct, that the individual has failed within that period of time. What we understand is that the reason for the dismissal must still be on the grounds of conduct, capability, a statutory restriction, or what we know as an SOSR, which is some other substantial reason. For some reason, redundancy is not listed there at the moment. But again, you must adopt a fair and transparent process and have clear rules around all of this. Now, we're already advising clients around this in terms of what to expect. But I think the main focus that we are saying now is that whilst in effect, we've probably had a 2-year probationary period in effect because individuals didn't have unfair dismissal rights, your internal processes are going to be really important. And what I mean by that is not just policy. Where are your checkpoints? How often are you evaluating and assessing the performance and or the conduct of individuals during a particular period of time? And you're going to have a finite period in which to really understand where that lies. So again, what we are saying is that if this comes into force and into practice, it's likely to be 2026. But it is still subject to a lot of consultation during this calendar year. So I think we'll be keeping our clients updated in respect of any challenges around that or any changes. But at the moment, it looks as if it's going to be a limited ability to terminate early. And it's not something that we're used to at this stage because we've obviously had operated around a 2-year probationary period in effect in terms of the unfair dismissal rights. So that's probably what I would focus on in that sense. The next area is around flexible working. Now, at the moment, what the right is you have the right to request flexible working. You don't have the right to flexibly work. So the language around this is shifted slightly as if it suggested that the flexible working ability is the default option from day one. So whilst refusals remain available, they have yet to still remain reasonable. And it's not just ticking the box or the exercise around all of that. And again, the reasons must be in writing as well. So the justifications for the refusals should be properly considered. And again, will trial periods become more common? So what I would say around all of that is, we still don't know how this is going to look. Okay, so but it's good to be aware of this. And I think the main area of challenge that we see now in cases in live tribunals is where there has been a failure to follow a proper and fair process, or it doesn't appear that the business, whether that be a manager, the business itself, operates any form of flexible working, doesn't consider it in the right way, doesn't rely on the statutory reasons as to why you can perhaps reject a flexible working request. When an employee feels unlistened to, or where they feel that something that they have put on the table hasn't been considered properly, that is where you have genuine issues and more likely to have a higher risk in terms of your claims or your claim profile. So I think that's something to be aware of, not just for when this may come in 2026, but now when you are dealing with flexible working requests. So that would probably be my key tip right now, is to make sure you have a very robust process that is genuinely considerate of the areas around flexible working and the reasons why, if you want to rely on why you cannot agree to a particular flexible working request. Don't be closed off because it's something that you've never done before. It's just not what we do as a business. That won't go down well in tribunal. Okay, so you need to be able to demonstrate why you might reject something on business grounds. Is it detrimental to the department, the team, client output, client process? So again, just be mindful of that, because that's where I would say the common pitfalls are with flexible working requests. And if this becomes the default option, what I'm also saying to businesses at the moment is you might get more flexible working requests at the recruitment stage or early doors when they have started or commenced employment with you. So be clear on particular departments or particular roles or particular areas within the business where you feel maybe flexible working would be more of a challenge. Demonstrate that you've been able to checkpoint that and you've assessed it and be more prepared in that. And again, don't make assumptions about what other individuals within a team might be willing to agree to or not. There might be some flex within teams or departments. And if you don't consider that as part of any assessment, then again, that would be an area of challenge in my view as well. So again, I'm not quite sure how many businesses here operate any sort of 0 hours or low hour contracts, but there is some proposals around all of that, again, to kind of bolster the protection of individuals who are engaged on that basis. So there is a requirement or proposed requirement that you would have to offer them a contract or to vary their existing contract to guarantee minimum number of hours in relation to a reference period where they've already worked. It is suggested that that's going to be a 12-week reference period. And again, even if the worker or the individual does not agree to that or they don't require it, there is going to be a proposed requirement around having those checkpoints in place after another reference period. So it's not going to be enough for you to demonstrate that you've asked the individual once and they didn't want it. You have to make sure that your process has in place those certain checkpoints to see whether or not this is something that they might want to consider further on down the line. And again, it's going to be more prevalent in the future due to seeking more flexibility and again, thinking perhaps differently about how you attract employees. I know in a number of sectors, recruitment and indeed retention is still a challenge. So again, if this is a likely barrier to recruitment in respect of what hours you offer or what hours you are able to guarantee, it's something that businesses are probably going to have to think about more as well. This is something that has been put forward as a proposal around the fire and rehire, a process that we currently have in place. Now, I've advised on numerous occasions, on numerous projects around fire and rehire from a strategic and tactical perspective, but also a genuine operational business need where there might be changes in terms and conditions of employment. Maybe things are being refused, and the only best way to kind of get this over the line from a business perspective, once consultation has been exhausted or any internal discussions have been exhausted, that the only option available is to then dismiss and re-engage or to fire and rehire. And I would say a lot of press interest can be thanked from the P&O disaster, quite frankly, from I think last year or the year before, where they fired and rehired the entire employment team, and it hit the headlines for all the right or wrong reasons, whatever your views are on that. So there's been a lot of consultation around that and how businesses deal with fire and rehire. So there is going to be proposed restrictions on the ability to amend terms and conditions of employment. I think that's going to be quite challenging for some businesses as well, because I understand that the proposals refer to where it's going to be huge financial issues for the business. That will be the only basis on which you can fire and rehire. Now, many of you on here today might have had to deal with a fire and rehire situation or dismiss and re-engage for reasons that don't lead to, but are not for the reasons of financial issues. It could be around changes in terms and conditions of employment that employees are not willing to agree to. So the only option left open to you once you have tried to deal with that and exhausted internal processes is to kind of dismiss and re-engage. That suggested that it would be an automatically unfair dismissal in these circumstances under these proposals. And that's not something that that's not how we operate right now legally. So again, that could be an issue for businesses if there is limited scope in trying to push through new T's and C's if that's required. Again, normally when you're dealing with 20 or more employees, if you're going to fire and rehire within a 90-day period, that is suggested that if you have to collectively consult on those basis, then again, you've got a protective award of 90 days gross pay per employee, which is a huge financial risk already for businesses, but there are proposals to increase this to 180 days. And I think that's just seen as more of a penalty based on employers or businesses who do not wish to go through a collective consultation like P&O did, for example, and they want to make sure that there is a broader scope from a compensatory perspective that the employment tribunals can perhaps award if there's a blatant disregard to any sort of fairness or process. And again, so it could be potentially very expensive if you get that wrong. So in terms of preparing yourself for this, I would just say keep an eye on this. Make sure you're appraised and you're kept up to date as to when this is likely to come in. We're thinking this is around the 2026 mark. I still think that there are particular areas that don't work right now as the proposals currently stand. And I think a lot of businesses will have a lot to say around this particular proposal, because the inability to dismiss and re-engage for areas that don't just relate to financial issues, I think limits the scope and for businesses to kind of manage their business in the right particular way. So I think that's an area of it focus in the next 12 months or so. The other area is around collective redundancies. Again, if businesses are looking to make redundant 20 or more employees within a 90-day period, they are under a duty to collectively consult, whether they've got unions or employee body internally or through an election, the established elected representatives. So normally what you've been able to do based on a previous case, the Woolworths case, is deal with that on a site-by-site basis. Where is that employee engaged? Where do they carry out that work? So if there's not 20 or more employees at a particular office, a particular site, then collective consultation requirements won't be triggered. However, this proposal suggests that what you're going to do is look at the business and the employer and the organization as a whole. So what this means is that collective consultation obligations are likely to be triggered more often than they are now, because of the requirement to broaden the establishment point and to consider where else in the business are you making redundancies, even if they don't relate to the particular sites or depots or departments, wherever it could be. So from a business perspective, I think this will be challenging, because you're going to have to make sure that you're fully aware, or if you've got a national business or an international, mainly national business, what's happening in all the offices and all the other sites to make sure you're not triggering something collectively that you need to address on a collective consultation basis. So I think you need a wider awareness of what's going on there. So in terms of learning and what's required there, that would be making sure you have the internal processes required to make sure that you've got to check on your numbers or when you are likely to make redundancies, so that you're not falling foul of that particular requirement. In terms of family-friendly rights, again, this is just the fact that there are a number of day one rights. Normally you've had to have had 26 weeks service before you have these rights, but these are being proposed as day one rights in respect of MAP pay, paternity pay, again, unpaid parental leave and bereavement as well. There is also additional protection in respect of maternity, and that relates to dismissal protection for those returning from maternity leave. Well, it will be unlawful to dismiss a pregnant woman or those returning from maternity leave for a period of 6 months after they return, again, save in limited circumstances. But save in limited circumstances haven't yet been defined or clarified for us, so I'm unable to kind of tell you when that would apply. But again, it's just to be mindful of the fact that these are going to be day one rights rather than something that requires a particular period of continuous service. So you can see a general theme here in terms of the proposals about bolstering employee rights as soon as they start employment, and the requirement for a continuous period of service not being there for a lot of that. So again, so a greater need generally will be required to understand leave and pay obligations. So you just need to make sure internally those that are dealing with those aspects are fully aware of how that will operate within your business as well. And again, in respect of covering work, fixed term contracts might be more required as well. Just a quick mention around statutory sick pay in that there will be no 3-day wait before SSP is paid. Normally you don't get SSP for the first 3 days of sickness, but again, the proposals are that there won't be a 3 waiting days. And again, the requirement for the lower earnings limit is to be removed is also there, but they've not actually mentioned whether or not there's going to be an increase in the amount to be paid, but there is a likely increase in terms of the financial burden. If we think about the fact that I think around 1.3 million employees currently earn below the lower earning limits who will now then be afforded this protection, you can see how that will have a knock-on impact on businesses across the sector as well. So again, just to be mindful and aware of that. There is also the Fair Worker Agency that is being proposed, and that's going to be a single enforcement agency that will bring together a number of government bodies to deal with enforcement in these particular areas. So it's around enforcing the statutory employment rights around a national minimum wage, SSP, holiday pay, amongst others. The other one is around ET awards. If any of you are not paying your ET awards, which I'm sure you're not, but again, it's just to make you aware that there is this body that will be looking to enforce and regulate this as well. So again, the stated aims are to support workers and good employers and punish bad ones. So again, how they plan on doing that is yet unclear, but it is clear that this is coming into play in terms of an agency being set up. And again, the real impact probably remains unclear. But there are likely more rules to follow, to be honest. We've noted that there could be more cost and therefore risk, but I think that is only really at play if you're not doing things right already in terms of paying the right amount in terms of wages, your SSP or holiday pay. So again, internally from a calculation perspective, operational and an education perspective, you just need to make sure that you've got your house in order and you've got the right people at the helm dealing with those particular aspects to make sure that that's all done right from day one as well. In terms of what's likely to come this year, we're going to focus on those 4 areas. We mentioned the fire and rehire aspects. So the ACAS code of practice is in play at the moment. So again, I would make sure that your HR teams or whoever deals with HR or who might deal with any sort of dismiss and re-engage or fire and rehire is fully aware of what that ACAS code of practice looks like. And the reason I say that is because starting from the end of this month, 20th January, it is something that employment tribunals will take into consideration. So if there's a claim in respect of dismissal and re-engagement, and you have not adhered to the code of practice, it is one option for the employment tribunal to increase any protective awards by up to 25%. So again, we don't want that. We want to avoid that. So that's why it's really important for businesses to understand what is required of them in respect of the code of practice and the process there. And again, the code just simply encourages employees to engage in meaningful dialogue with employees to explore all available options before seeking to dismiss and hire on new terms. So again, what's really important there, and when I've been addressing and advising clients in respect of dismiss and re-engage, is that's the end point for you all, okay? Whenever we're looking at any dismiss and re-engage process, whether it's between 5 employees or 100 employees, I always say to my clients, what's your business reasons for making this change or for closing the site, or what's the rationale? Really pin down your rationale and understanding of what the requirements are and why you're doing this and when you're likely to do it. Think about putting yourself in the employee's shoes as to what areas of challenge there could be so that you can preempt that as well. Not because it means you can just dismiss any issues raised around that, but more so that you're prepared. Because normally whenever you go through a dismiss and re-engage program, timing is really important. If you as a business have got something to deliver within a particular time scale, you not having to rush around trying to understand or trying to answer these particular questions, on the back foot can save you time. So again, being prepared for these particular areas of challenge is key, and it's always something that I say to my clients to make sure that they are fully prepared. Have some FAQs already prepared, make sure you've got good consistent communication channels, make sure you've got the right individuals in place and in post from the business's perspective to carry out that process as well. So again, it's not there to penalise businesses that have business decisions to make and carry out. It's when it's not done properly by way of consultation, genuinely considering any proposals that are put forward, genuinely considering whether or not you have to be so hard in particular with any particular decision. So again, I think that's really key in my opinion. Again, not going to go into too much detail around that. It's kind of as it, it does what it says on the tin kind of slide in terms of you've got national minimum wage increases, which come into effect on the 1st of April. They come into effect every 1st of April. So again, I'm sure you're well versed if that's the case. But again, just making sure that you are aware of what they are and when they come into play. In terms of the neonatal leave and pay, there is an expected date of implementation and impact in April this year. It's likely to be a day one right as well. There are going to be regulations in force to kind of give us a bit more clarity around what this will look like. They're not there yet. But again, it's in respect of eligible parents of babies requiring neonatal care, and they'll be entitled to up to 12 weeks of paid leave, which the pay would be very much the same, if not exactly the same as those on maternity leave and paternity leave and shared parental. There's never any difference in that kind of rate of pay. And again, that's in addition to existing parental leave rights. So it applies when a baby receives neonatal care for more than 7 days in a row in the first 28 days of life. And again, when this comes into play, you need to be ready to update your family leave policies to accommodate this. So if you haven't already started it, my view would be to kind of have the bare bones of what we think is understood in terms of the neonatal leave and pay relevant in your ready in your policies to kind of go from April. And again, the how and the when the leave can be taken, which again, I've noted there, it's got to be taken within a minimum of 68 weeks from the child's date of birth. That's something, again, that we don't have clarity on yet as well. But when we do, we will share that with you too. The last area that I wanted to cover was around the failure to prevent fraud. So the effective date of this is the 1st of September 2025, and it's a new corporate offence that will hold organisations accountable if they fail to prevent fraud committed by an employee or agent for their benefit. So it really changes and emphasises the importance of fraud prevention policies and robust internal controls, to be honest. And again, I've noted there on the slide, it applies to large employers with a turnover of over 36 million, total assets of over 18 million, or over 250 employees. So what is key as a takeaway for you all today is that you need to probably review and strengthen any current fraud detection and prevention procedures that you have internally. Do you conduct regular fraud awareness training for staff at all levels of the business? Again, if not, that's something that we would recommend you put into place. And again, make sure you establish robust internal controls to detect and prevent fraudulent activities as well. That's going to be absolutely key. And I suppose it's just a reminder that of proactive risk management within your organisation, and it's essential for your legal compliance and organisational integrity as well. So I think it's not a bad thing. I think it's a good thing. But again, the onus is on you as a business and as an employer to make sure everyone within the business is aware of what you consider your obligations are there to prevent this as well. So the last area I want to kind of address is around preventing sexual harassment in the workplace. Okay, so the Act came into force in October, and I'll be honest, I don't know how many I've done so far, but I have been inundated with requests and carrying out training in this regard as well. It's an absolute must for you all here. And there is a duty to prevent sexual harassment of your employees, and that's by your employees or any third parties. So that's the strand that I think that has added a bit more weight around this level of protection as well. And the requirement is to take reasonable steps to prevent anticipatory. It's required for you to be anticipatory and also reactionary. So I think most of the time businesses are very good in the main at reacting to something. But again, what you have to be able to demonstrate in your policies and your processes is that you're taking reasonable steps to prevent this. And that requires an anticipation. That requires the anticipatory level of control and understanding around this particular area. So again, you shouldn't really be waiting until there is a complaint of sexual harassment. You should be training your senior exec teams, your managers, and all members of staff. Now, I think the training will differ slightly between members of staff. But again, you want to make sure that your leaders are leading by example. They don't walk past things that they shouldn't be. They are leading by example in terms of how they conduct themselves in the workplace. They are enforcing a very good and positive workplace culture that allows for open discussion around any issues that might arise in this regard as well. I will say this, we've obviously got 9 protected characteristics ranging from age, sex, pregnancy, race, religion, etc. And there has been a spotlight shone on sexual harassment. Now, one of the most common questions we're getting at the moment is, do we just focus on sexual harassment? The answer is, of course, no. You have to make sure that all your employees are protected against any form of victimization or harassment on any protected characteristic. But there is a certain light shining on sexual harassment at the moment, and there is a legal obligation to make sure that you are doing that. So the view that we are taking is make sure you cover off all forms of discrimination, harassment in respect of the protected characteristics, and make sure you make it clear that there is an additional element in respect of sexual harassment as well on the back of this duty introduced in October as well. Okay. No protected characteristic is trumped by another. So it's something that you need to be mindful of as well, and how you position that internally. What I will say as well is that there are common workplace challenges with sexual harassment. The number of employment tribunal claims that we deal with has increased over, I would say, the last 4 to 5 years in respect of harassment, not just sexual harassment, harassment on the grounds of other protected characteristics as well, but there obviously with the Me Too movement and, you know, some political and celebrity issues around sexual harassment as well. It is a very topical area at the moment, and quite rightly so. So I think that the main challenges around this we find around workplace banter. I always say that one person's line, or you crossing the line, is different to the other person. It's a very subjective aspect. We have, all of us, perhaps some unconscious biases as well. We also have a very different parameter as to whether or not we're offended by something or not. So I think when I give advice around this, and when I deal with the equity, diversity and inclusion training for clients and contacts around this, I think you just need to be mindful of the fact that if you are in tribunal, and if your solicitor has to ask you when defending the business or defending you, because you as an individual as well can be named as a respondent for sexual harassment, not just the business, so you could be personally liable. If there's a question asked, did you say this, did you do this, and there's any part of you that feels, oh, did I, or you want to say yes, but you now kind of have to check your own internal barometer around these things as well. It's workplace banter, it was just banter, has never really been a successful defence for any business or for any individual who is named as a respondent. Again, there can be challenges around whether or not there are workplace relationships, depending on the particular individuals and roles carried out. by those individuals, and if the relationship sours in any particular way, and how that impacts on their day-to-day working life as well. Do you have any policies and procedures around how you would deal with that to make sure that there's no sort of victimization or harassment in that respect as well? And again, there can be accusations around the abusing of positions of authority as well. So the key take home in that respect as well is, I think we need to be careful that we don't make assumptions about what other people's comfort zones are or what they think is acceptable banter or acceptable forms of communication. We are obviously more in an online social media environment and population. I would also say, as having been doing this for a number of years, and in particular, I think over 20 years now, we see WhatsApp chats, Snapchats, Instagram, I think of other modes, where there are screenshots now that are led as evidence. So we have a very big digital footprint provided to us as solicitors and as businesses, where they are led as evidence in lots of tribunal claims at the moment. So I think that's an area of focus or general understanding that businesses need to be aware of, that even Teams chats where you think you're having a joke, I dealt with one last year actually that was quite nasty. These were all screenshots and relied upon by the particular individual and the claimant. So again, if you don't want to see it in tribunal, don't send it, quite frankly, or don't do it. So I think these are areas of challenge. And what I will say from a business perspective is that to keep yourselves right, you need not only to have really robust policies and procedures, checkpoints in terms of reporting, a safe space, confidentiality, make sure you've got the right champions in place for this. You need to walk the walk as well as talk. There's no point having all that paperwork, all those policies, if you don't act on it, if you don't genuinely live and breathe those values, stick by your culture. And I always say that doing nothing can just be as bad as doing something that's not recommended either. So any omission, that's not ideal as well, and that can be relied upon. In terms of the duty to prevent sexual harassment, what I would say is there's obviously technical guidance online around all of this, and there's a really good 8-step guide that is provided in terms of preventing sexual harassment at work, and there's some good technical guidance as well, and so ACAS has provided that too. So there is a huge amount of literature out there in respect of this, so it's never going to be acceptable for a business not to be fully aware of what's required of them, or again to not say that they've got a good standing point. You've also got us as well. We are obviously legal advisors, and that's what we've been doing for our clients as well. But again, the main thing here is that as a business, you need to be on this. You need to be aware of this as well. In terms of the training as well, sometimes we have not had resistance, but there's challenging conversations around how do they report, what's the confidentiality around this. And also, when you've had long-standing businesses that have had, I would say, very low loss of employees, and there's been good retention, where culture has just always been this way, we've always done it this way, it's never been a problem up to now. You've got to really think about the individuals that are coming into the workplace, the next generation. They are more than not only keyed up and clued up on all of this, they have a level of expectation, quite rightly so, as to how they expect to be treated and how a business should present themselves as an employer in terms of how they deal with any particular issues. So you want to be at the front end of that. You want to demonstrate, we're on this. These are our expectations in terms of behavior and conduct and management, by leading by example. And in respect of that, I would probably come on nicely to this in that I want you to have a think about yourselves as a business and leaders. And it's a big word for me at the moment, allyship. How are you an ally to those that have an issue with this or who want to raise a complaint? So are you a positive influence on creating a supportive and inclusive work culture environment? If you are, how are you demonstrating that? How are you communicating that? And again, if you already have policies and processes in place, make sure that you're fully familiar with what they are and what they say and how they work. and I say there, be an ally. I mean that. I mean all walks of life. I recently did an equal pay talk in London for barristers, and there's a disparity there between female barristers' pay and the male barristers that are seen, after 1 year of calling. Now, normally it's suggested or explained that the reason why there might be a disparity or an inequality in pay is because most women go away and take some time out for family commitments. But the fact that this took place within the first year of calling would suggest there's something inherently an issue, inherently a problem in terms of equal pay. Now, I'm not saying that's the same with harassment. What I mean there is that during that conversation and that talk, I asked everyone in the room, the males and the females, around, why do you think that is? Why do you think there are individuals being treated differently or being paid differently? If there's any insight that anyone can share and be a genuine ally and genuinely supportive around these particular areas, make sure that you are doing that and you're having the right environment to foster that kind of culture as well. Again, know what you're doing when you're addressing or handling complaints for sexual harassment. One of the biggest challenges that was recently reported was that those that had felt that they had been sexually harassed in some way didn't have the confidence to raise the issue because they didn't think it would be taken seriously. They didn't think they would be believed. So if that's already a genuine barrier for these particular issues, you need to overcome that. How can you make sure that the individuals dealing with these complaints or addressing them are the right people? They're well trained up. They know to encourage individuals to speak out where required. What kind of culture do you have? And again, there's a huge PR aspect around this and reputational risk if you don't get this right in your business. Word spreads about as well if there are any issues around how you deal with sexual harassment or if there's a culture of it in any way. So again, make sure that you don't want to be at the wrong end of that in any way either. And again, I've said there that, and I've mentioned it already, that individuals can be named respondents now. And we're seeing that tactically in employment tribunal claims, whereby employees are raising claims of sexual harassment against the business, but also particular employees, predominantly their manager or another colleague. So again, being aware of how you're going to deal with that tactically as well is also something that you need to consider. And again, make sure you're engaging your team and your colleagues by leading by example in it all. Because, like I said, it's all very well having all the paperwork, having the policies and processes, but if you don't actually live and breathe it, you're not confident with it, you don't understand it in any particular way, then that shows and that emanates and that forms part of your culture as well. And I think culture is hugely important at the moment, especially where retention is a challenge. As I say, employees don't leave necessarily bad businesses, but they leave bad managers. So again, be mindful of that as well. So I think that takes me nicely. And can I just say I'm super impressed with myself for having done this within, I think, the allocated time slot. I thought I would run over and I haven't. So I hope I haven't spoken too fast. I hope it's all made sense. But if there is anything in particular that you want to ask a question around, I'm more than happy to stick around for some Q&A sessions right now. Thank you.
Ingrid, thank you so much. That was really, really interesting, really insightful. I think it's an absolute minefield, isn't it? I mean, there's so much to digest. I mean, I think the really topical ones at the moment are, as we went into great detail about the sexual harassment, but also the flexible working. I mean, that seems to be something that increasing people expect it to be, something that their employer will agree to. I mean, just before anyone else has any questions, if I might jump in and ask one, if that's all right. I mean, I'd be interested to know what the sort of common reasons are for an employer to deny a request for flexible working. Is it, so there's an open question. Rather than me answer it, you answer it.
Yeah. So it can be for a variety of reasons. I touched upon some of them, but like if you're able to demonstrate that having someone do less hours, or which could lead to less output as well, has a detrimental impact on how you service clients or the knock-on impact on the particular department, that's one. But I would challenge you as a business and say, Why can't you do a job share? Why could you not have someone else come in and do that one day? Or these might not be suitable solutions for you as a business, but I want you to tell me why you've considered it and why it's a no-go for you.
Mm.
So at the moment, I'm sure what's required is that employees are required to demonstrate, or they were required to say how their flexible working request would have an impact on their department, on their team, whereas that's now not the case. Like, businesses need to think about that. It's not for the employee to almost fix it for the business.
Mm.
The business needs to consider it. So the main pitfalls around flexible working, and you're right, it's a huge area of challenge for so many businesses at the moment, is that employees don't feel that it's been considered. And a lot of managers who have been in post or the business has worked in a particular way for so long, they just say it wouldn't work. No, it's absolutely no way. It's not going to work. We're not going to do it. But they've not really thought about it.
Mm.
And that's where you'll come unstuck if there is a tribunal claim around that. And not only that, whilst we are seeing a bit of a shift, most flexible working requests still come from women to deal with childcare arrangements. So there are indirect sex discrimination issues and requirements that you need to understand and make sure you navigate through sensibly as well. Because if you can't objectively justify a particular provision, criterion, or practice that has places a woman more of a disadvantage than a man, then you'll fail on that count as well. And again, no one wants to have a discrimination claim against their name either.
No, thanks for that. I mean, it's interesting. I mean, I'd also be interested to know on how, as a sector, you know, the insurance sort of sector fares in terms of flexibility. I guess again, it's a bit of an open question again, but I mean, are we generally good, or is it a sector that really needs to kind of move with the times a bit more and wake up a bit more and just, you know, be a bit more flexible than they have been in previous years?
I understand that as a sector, I think it'll have pockets like any others. I think one of the biggest challenges from a flexible working perspective that's been on the cards is when you've seen the businesses trying to bring everyone back into the office.
Mm.
That's been a huge
Yeah, there's
challenge.
a lot of news about that at the
Yeah,
moment.
huge. And you've seen it go from a PR perspective slightly wrong, where businesses have just said, you're all coming back 5 days a week, we don't care. And the employees' challenge around that is that we've obviously, through COVID, we managed. So why can we not continue? There's been no
Yeah,
issue with output. So when I've advised clients around that, what is it you're trying to achieve by bringing everyone back 5 days a week? Usually it's more around collaboration. It's around culture. It's around the fact that it was never intended to be an off-site role in the first place. You did it before. But I think those that have done it well have communicated that effectively, but also still demonstrated a bit of flex, where it's more around between 2 and 4 days in, for example. But you need to back yourself as a business as to why you think that is necessary. It's not enough to just say, well, we did it before. Why?
yeah,
And I think that's the main challenge that businesses face when they just want to go back to the status quo pre-COVID. Also, your contracts will no doubt still say that the person's place of work is the office. That
yeah,
hasn't officially contractually changed, but as we all know, or as the employment experts on here would know, is that you can challenge that by saying, well, have our T's and C's actually been varied? Is there now an
yeah.
implied right to this? So again,
Mm.
there's lots of discussions around that as well.
Yeah, amazing. Thank you. Okay, enough from me. Does anybody else have any questions? I mean, there was nothing posted in the chat, so I don't know if people are just a little bit shy or whatever. But any opportunity? Anyone want to ask anything? Speak now or forever hold your peace. Doesn't look like it. I can't see any hands
Yeah, please
raised.
don't be shy. If there's anything, that's fine. Otherwise, I will take it as an absolute glowing win that I've covered everything possible that you wanted to hear about this afternoon.
I would absolutely take it as that. Thank you. Gary's posted a lovely comment in the chat there, so thank you very much. I would take it as that completely. But before I sort of wrap up, just to say that as Ingrid mentioned, you feel free to reach out to Weightmans if you've got any questions. Their contact details can be found by going to the membership directory area of the MGAA website, giving a little plug to our own website there, which is good.
Very much.
But that would be lovely. But Ingrid, thank you so much for your time and for delivering that. It was an excellent presentation. I really hope that a lot of people have taken away some really valuable insights on that. And as I mentioned at the beginning, we will share the slide deck afterwards. It might really be useful if we can have some of your notes on the slide deck as well, Ingrid, once you've had a look at those, because I noticed there was a lot of info on there which people would really like to take away with them. So just for everybody else, thank you all very much for joining us, and just want to remind you about the feedback survey. If you could complete that and send it back, that would be great. And do keep an eye out for our other events on the website. But to everybody, thank you for joining us and have a lovely afternoon. Ingrid,
Thank you for having me. Thank you.